experience to consistently exceed expectations. Specializes in making the complicated simple, understanding the big picture, and adapting well to a variety of projects and work environments. Her specialties include litigation management, eDiscovery identification, preservation and collection, project management, discovery analysis, plan development and execution, and complex litigation, including class actions. She is especially skilled in concordance, relativity, live note, case map, exhibit view 5.0, legal hold pro, smart sheet, Adobe, and Logical. I also can say that Angela is the current chair of the GW Paralegal Alumni Association, co-host of this event along with Paralegal Studies program. She's been the chair, this is her second term. She's also an ACP, Advanced Certified Paralegal, which, if I understand correctly, there are less than 50 in the country.
In eDiscovery.
In eDiscovery. And we have two of them here, Angela and Michelle Hess. So with that, I'll give you Angela. And if you wanted me to pass out some materials.
I have handouts. Okay, so I know that you're probably, if you're not familiar with eDiscovery already, I'm sure you've seen this graphic over and over again. So what my purpose here today is to give you from non-attorney legal professional to non-attorney legal professional a real understanding of the specific tasks that you can use anytime that you are asked to work on eDiscovery. I want to give you real-time knowledge that you can take away from this event and be valuable to your legal team as soon as you leave here. So what I did is in each phase of eDiscovery, I color-coded the specific tasks that you may be able to do to assist your team. So instead of constantly referring back to it, I just thought it would be easier for you to have the handout with you. So I'll give that to Tony. I have another quick handout as well. In putting together the first Paralegal Tech Talk event last spring, it led to this event. It went from an evening 2-hour event to people saying, we want a specific event about eDiscovery. It sounds like that is what is happening right now. We're here today. And in that process, I found out about a scholarship that True Staffing has. I applied for it and I got it. So I was able over the summer to take additional courses that prepared me to be a litigation support analyst, building databases with concordance, load files, learning all about the different, advanced litigation support tasks that are part of the eDiscovery process. So I'm going to give Tony that. I would like to mention, if you're interested in this, it's an annual event, but if you would like to apply now, unfortunately the deadline is tomorrow. It's possible. In your little short essay, you could say, I was so inspired by this event at GW that I want to be a part of this program, but I would highly encourage you to apply if you're interested. But it is every year. If you don't want to apply by tomorrow, it happens every year, and I would encourage you to do that. Okay. So thank you, David Gaston, for that wonderful basic introduction to eDiscovery. Right on. I love to see his passion. I think people, when they love eDiscovery and they start talking to other people who love eDiscovery, it's just like bees in a hive. We're all excited. We love it. So yes, I want to continue to spark that fire in you to love eDiscovery, because it's not where the industry is going, it's where the industry is now. It will make you highly marketable and very valuable to any legal team that you are a part of. So, as Tony mentioned, I am an advanced certified paralegal in eDiscovery. How I was introduced to eDiscovery was just before I started the master's program. For 2 years, I worked with in-house counsel at a Fortune 500 company. I was the sole paralegal who was given the responsibility to organize eDiscovery for operations in 48 states and respond to every subpoena and every information request that the company received. So in the 2 years I was there, I responded to approximately 200 subpoenas or information requests. So once I took the master's program, I was just really inspired to communicate how important this area of law is to your paralegal career. So, having said that, we will start. So, looking at this map, you will become familiar with it if you aren't already. There is a role for you as a paralegal in every phase of this process. Don't let anybody tell you anything different. So as David covered shortly, what is information management? It's the first process. If you get this first stage right, it can set you up for success. And you can have a role in helping form how the agency, the company, the law firm, your client handles their documents. So information is really about how documents are created, stored, and even destructed. Saving data can be expensive. So it's also important to know what data you no longer need. It's important to know what data you need to save. It's also important and costly to save the data that you don't need. So once you get this first stage right, you're going to mitigate your expense and you're going to mitigate your risk. If you're saving documents that you technically don't need to save because of state law, federal rules, or whatnot, you could be setting up your company for exposure because you have information that might set them up for a lawsuit. But because you're keeping it, even though you don't need to, that's lending to some exposure. So what are the specific tasks in information governance that you can do as a paralegal? You can do research on the rules and the case law that tells your company, your client, your agency when, how long they need to retain documents. What are the strategies that they're using to keep, save, and destruct documents? What is it on paper, as David said, with the letterhead on top that's going to make you look like a rock star if you put it together? It really will. If you help people figure out how to do this properly, you will be highly valuable. So if you're able to be a part of the team that determines what that information preservation strategy is going to be, you're going to be valuable. In addition to how legal hold and data management policies and questionnaires are handled in the company or the agency. And is the company or the agency in compliance with all of the rules? Are they doing what they're supposed to be doing? If you can help them determine what they're doing, how they need to do it the right way, you're going to be highly valuable. You're going to be saving them money. You're going to be saving them risk. You're going to mitigate their exposure. So the next phase on the EDRM is identification. Okay? One great way to look at this phase, you're going to see this often, is early case assessment. Okay? This is no different than getting in a complaint. You're going to assess the claims. You're going to help identify the key issues. You're going to locate the data. One very important role that you can have is thinking of all the places that there's going to be data. It's not just going to be the cell phone. It's not just going to be the computer. It's going to be the computer that does the punch card. It's going to be the video camera that videoed somebody coming into the garage before they were robbed. It's going to be all of the different places that we store data. Data is being created at an exponential rate. Mobile devices outnumber the number of people in the world now. We duplicate the internet every few years now. 9 out of 10 documents that are created are electronic documents. The amount of data that there is to locate, it's amazing. The potential impact on litigation is, you know where the data is that's going to help you defend your case or help you understand what your exposure is. That's highly valuable. So how are you going to use that case assessment? The very beginning of any case that concerns eDiscovery, you're going to have a meet and confer. Those parties have to meet early, and they have to decide how they're going to handle the data. Okay? So as a paralegal, one of the things that you can do, I can help you assess the data, and I can help you prepare these initial disclosures. I can help you put together your initial discovery plan that you're going to be able to take to this meet and confer and look prepared and look like you know what you're doing. Okay? After 14 days after the meet confer, you're going to have to submit that document to the judge with a stipulation and an order saying, look, this is how we think things should be handled. I know what I'm doing. I don't know about opposing counsel, but I know what I'm doing. And if you need any guidance, I will help you. But really, being able to be valuable in this very beginning stage, you're going to set up the case for success. You're going to save your company money. You're going to save your client money. Okay? And at the end of the day, I'm here. What has led me here is my passion for helping paralegals be the best that they can be and to be valuable to their legal teams. So I hope at the end of the day, you really understand how learning about eDiscovery will help increase your value. Okay, so I really loved it when David talked about all of the communication that you're going to need to do in eDiscovery. It's interesting how utilizing technology can really lend itself to just picking up the phone and making a connection with someone and smoothing over the process. So one of the things that you can do in the identification phase is serve as a liaison. You can pick up the phone and say, hello, I know this legal thing seems really scary, but I'm here to help you. It's not that scary. I'm going to be the person that's not going to speak all the legal jargon. I'm going to tell you directly what we need, and it's going to be okay. So, and part of that process too is telling people it's going to be okay, but I also need you to tell me what you know, and I also have to write that down, and I have to track it. So that was another part of David's presentation that I really loved. Emphasizing documenting everything that you do. Track it. Who did you talk to? Who did you not talk to? And why? What did they say? What did they say that they have? How do they work? What information are they going to have that's relevant to our case, that's going to help us or maybe not help us? What is not going to help your case is sometimes can be just as important as what's going to help your case, because then you can start mitigating the circumstance. So you're going to start preparing, as I mentioned earlier, for that Rule 26F stip and order. You're going to start preparing those initial disclosures that are going to be required. You're going to say, this is kind of how we see things. This is kind of what we have. So part of that identification is you're going to start thinking about how much is this going to cost us? You're going to have to start communicating with your client how bad the damage it might be. That communication with the client is very important. So one important requirement that attorneys have is they have to make a reasonable inquiry according to the Federal Rules of Civil Procedure. They are required to do their own due diligence in the case. Kind of, sort of interviewing people, kind of, sort of knowing where the data is, that's not good enough. Judges are increasingly impatient with attorneys who don't know a lot about technology or are unwilling to know about. They need to know, and you can help them. So again, I'm going to emphasize, as a paralegal, you can really keep that information flow going. You can be that person who's the friend with opposing counsel's paralegal. Hi, I need X, Y, and Z. I know our bosses are not getting along, but we can, we have this deadline coming up. I'm here if you need anything. I know that we all agreed it would be provided in native format and usable, blah, blah, blah. You can really grease the wheels in how you deal with other people on the other side. You're also going to need those skills when it comes to working with vendors. You're going to be interviewing custodians who, as David talked about too, when they get a hold notice, they're going to want to climb up a tree. They're going to be upset. They think it's the equivalent of being sued themselves. So you're going to have to pick up the phone and say, look, I know you got a hold notice. It looks scary. It's not. Let's just take care of it. Call me if you have any questions. And you can really, as a paralegal, use your communication skills to make the case overall go smoother. And that's highly valuable. For Federal Rules of Civil Procedure, the backbone of how litigation goes, you have a duty to disclose. You have to understand what you have. You have to tell the other parties what you have. You're going to, at the meet and confer, as I mentioned before, you can help prepare that discovery plan that your attorney is going to go to that meet and confer with. You can help prepare all of those things to make them look like they know what they're doing. So Rule 26 says, except in a proceeding exempted from initial disclosure under Rule 26A(1)(b), or when the court orders otherwise, the parties must confer as soon as practicable. And it's important to understand what this deadline is. It really sets that initial case evaluation into action. So, as you help with that due diligence in the case, attorneys need to be able to say, when they sign disclosures, when they sign discovery requests, we've made a reasonable inquiry. Is that your responsibility as a paralegal? No. But you can definitely help the case. You can definitely help a legal team not be sanctioned if you're the one saying, we haven't looked at this box over here in the corner. Are you sure we looked at all of the cell phones? Are you sure we looked at all of the laptops? So Federal Rule of Civil Procedure 26G, for good, requires an attorney of record to sign every discovery response and certify that upon a reasonable inquiry, the response is legitimate, consistent with existing law, and made in good faith. Okay? You're part of that good faith process. What if a good faith effort is not made? I brought up some cases to show you what the sanctions can be. Does that come out of your pocket? No. But when this doesn't happen in a case that you worked on because you were able to say, we didn't look at this, that makes you look really great. And it makes you very valuable. Okay? You can say, this is what can happen. Is every case going to have an $8.5 million sanction? No. That's an extreme case. But, as I put here, these beginning Rule 26 sanctions, they're increasing, and for less offenses. Judges are not, they don't have patience anymore for anybody who's not following the rules and doing what they need to do. Okay, so now we have the preservation stage. This is the stage where the legal holds come into place. You're going to hear this word over and over again, spoliation. And actually, I think I have it spelled wrong, but sorry about that. I think the I is in wrong. But yeah, this is your worst nightmare, losing data. So how is spoliation defined? A good definition is in West v. Goodyear. And I'm happy to send these slides to anybody who's here today. So what is spoliation defined? What is your worst nightmare as a paralegal working on an eDiscovery case defined as? The destruction or significant alteration of evidence, or the failure to preserve. Failure to ever tell anybody that they needed to preserve the information in the first place. For another's use as evidence in pending or reasonably foreseeable litigation. Okay? So what are the tasks that you can do as a paralegal to prevent this worst nightmare? You can assist in identifying those things that should tell your legal team, hey, we need to stop everything we're doing and all the information needs to be saved that's relevant. You can assist in drafting defensible legal holds. Later on, we're going to hear from one of our sponsors today, Logical. They already have that process for you. It's important that you know what a defensible legal hold is, and it's important to know how to draft it and what all the components are, even if you have a software that may go ahead and deploy that for you. You can assist a client in preservation compliance. Part of that assistance is picking up the phone and making them less frightened about the legal hold that they just received. Track and follow up on legal holds. We'll talk about this in a few minutes. Sending the initial legal hold, just sending it out, that's not enough. It's not even enough really anymore to send one. You have to follow up. Most cases go on for years. You have to follow up. New information is revealed in the case. You have to update that legal hold. Sometimes you'll get new information that will completely tell you that somebody who received the legal hold no longer needs to save their information. That's going to save your company, your client, money. Again, you're adding value. You're going to analyze the data for responsiveness. Okay, so you sent the legal hold. Employee Bob sent you. You collected his data. Are you sure? Look at it. Make sure that you have everything that you think you should have. Are all the pieces of the HR file that you need there? Are there any potential preservation gaps? So, given all of those things, you can also identify if somebody's being uncooperative. Is there a potential protective order that may need to be issued? And you need to be able to identify when those instances occur. So when does a party's duty to preserve information begin? Once a party reasonably anticipates litigation, it must suspend its routine document retention policy and put in place a litigation hold to ensure the preservation of relevant documents. Zuba Lake. This is a case, there are several Zuba Lake opinions. Be informed about what they are. Okay, in the realm of eDiscovery, it's one of those series of landmark decisions that will constantly be referred back to. This is just one of them. Okay, so here are some of the possible preservation triggers. This is one of the possible situations that you may need to talk to your attorney. They may need to get HR into place. They may need to get IT in place. You're going to have to communicate with these people, probably in this situation, to preserve the information. Did you receive a filed complaint? That's a big red flag. But lots of times, the duty to preserve is not triggered by a filed complaint. Was there a good faith threat of litigation? Not somebody saying, oh, I'm going to sue you. That's not necessarily a good faith, a threat of litigation. Did you receive a demand letter? Did you receive some type of correspondence? Are you aware of some information that increases the likelihood that you may be sued? A third-party subpoena, and we'll talk about that more in detail. Just because your client may have received a subpoena doesn't mean that they need to save every piece of paper regarding a situation. We're going to talk about possibilities where they may need to preserve more information than just responding to a subpoena. Was a complaint filed with a regulatory body? This is something that comes up a lot in employment litigation. You have to go to different regulatory bodies before it actually gets to litigation. A written request for preservation, that's a really specific indication that you might need to be saving information. And then in an extreme situation, you might get an ex parte order. An ex parte order is like an emergency action by the court saying, we have reason to believe data is going to be lost. You need to save it. So usually when we talk about the duty to preserve, we're looking at from a defensive standpoint. But if you're working for a plaintiff's firm that's initiating an action, you may have a responsibility to preserve information way ahead of the game. And you're not only responsible for the information that will support your case, but will also support the defense. So it's all of that information. If you notice somebody is not being as closely guarding information that might support the defense in your plaintiff firm, be aware. Let people know. We also need to preserve that as well. So a good case to talk about the potential sanctions that can happen if plaintiffs do not preserve the information they're supposed to is Syntega Inc. versus IDEX Laboratories. And in this situation, let's see, the next case, the Pension Committee of the University of Montreal Pension Plan versus Bank of America Securities, the plaintiff failed to issue a written legal hold at all. So it's important if you're working on the plaintiff side to not think that a legal hold is something that just applies to everybody else. It actually applies to everybody in the case. Okay, so one thing as a paralegal that you may often do, I found myself often doing, is preparing subpoenas. So let's say you work with a company who received one. What is that? They're not a party to the case. What is their duty to preserve information if they're not in the case? Well, in most situations, it's probably okay just to respond to the subpoena. But you might want to mention, hey, when we produce these records to the subpoena, I noticed some things that might be an issue in this case. You can go on Pacer, look up the complaint to the case. I often would do that when I receive subpoenas. If it was directed to our company and it was a federal case or a state case that I knew didn't cost me anything to access or cost minimal, I would go and look at the complaint, kind of compare it to the records that I would produce or suggest that we would produce that was responsive to the subpoena, and I would raise a red flag if there was any indication that we may be sued. So as a paralegal, that would be highly valuable. A complaint can take a long time to come your way. If it turns out that you're sued later on and your company didn't save the information that they should have with that subpoena, are you at the end of the day responsible? No. But you surely would be a superstar if you raised that red flag. So let's say the third party that is your client received a subpoena that was overly broad, burdensome to respond to. I bet you anything in this case, Thayfell versus Ferry Jones, I bet you anything that a paralegal prepared the subpoena, an attorney was not very careful with what he was signing, and it went out. The third-party subpoena in this case was not limited by subject, custodian, or time. It requested every email to or from the opposing party in this case. So the company that received it, which was an internet service provider, said, whoa, this is ridiculous. This is way too many emails for us to provide. It's going to be very expensive. They opposed the subpoena in court. The subpoenaing party got sanctioned $9,000. That was a bad day at the office. Okay? That was a day that a paralegal who knew what they were doing could have potentially saved the client the burden of being embarrassed, going to their client and saying, look, hey, we were sanctioned for $9,000. For what? We asked for some emails. That it wasn't specific. Okay, so protective orders. There are times when protective orders need to be issued. So a party or any person from whom discovery is sought may move for a protective order in the court where the action is pending. The motion must include blah, da, 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 da. So in case you need to prepare a protective order, this is how you do it, okay? If there's a situation, I can prepare that. Okay, great, thank you. Prepare a draft. Okay, so legal holds. You need to draft a defensible legal hold. Some of the main components of a defensible legal hold, it has to be in writing. I was laughing yesterday, I was looking at an old CLE that I got that from about 6 years ago that didn't even say then that it needed to be in writing. Not only does it need to be in writing, it needs to be verified that it was received. You need to track to who, what, when, where, and why. Get comfortable with Excel. You're gonna have to track these things. I know Logical has a great program that also will track these kinds of things for you as well. But if you don't have something like that, you need to know the things that you can track. You should track. Follow up. Zubalake again. Implementation of legal hold is just the first step. It's just the beginning. You don't send it out and forget about it. You constantly keep revisiting that list of custodians of people who may have information in your case. So as I mentioned earlier, another essential component of a legal hold is how to lift that legal hold. You have to make sure that the information that that person might have regarding one case isn't relevant in another case. And I think David also briefly mentioned the Sedona Principles. Along with the EDRM, it's another think tank that publishes information on the best practices in eDiscovery. In addition to the EDRM, I highly recommend you pull up the Sedona Principles, visit the website. They have a wonderful dictionary. They have a reference of all the terms in eDiscovery that you're going to consistently hear. There are lots of different new words that you're going to have to learn. Scope. Federal Rule of Civil Procedure 26B2B has limitations. Are you going to need to preserve every piece of paper ever saved by a company? No. You don't want overkill. That's expensive. Helping parties understand the scope is important, and it will make you valuable. A party need not provide discovery of electronically stored information from sources that the party identifies as not reasonably accessible. David talked about backup tapes. In many cases, those are not reasonably accessible. Or if somebody wants to pay the loads of money that it takes to actually access backup tapes, it's very expensive, then if the opposing party thinks that they want to pay for that the data on there is valuable enough to them, then they can do that. Okay, whoop. Let me do this. Okay, so collection. You're going to identify the people, you're going to identify the information that they have, and you're going to be collecting it. Federal Rule of Civil Procedure 26, again, it's important to note in requests for ESI that the signer certifies the requests are not unduly burdensome or expensive. We're talking about that again. You can't send out these crazy discovery requests that ask for every email sent by the company. It's got to be limited in time, to subject, and to person. Federal Rule of Civil Procedure 23E, a party must supplement its discovery responses whenever it learns that in some material respect the disclosure response is incomplete or incorrect. Those disclosures at the beginning of the case often change as you learn more information. Okay, so how, as a paralegal, how can you assist in this phase? You're going to start dealing with the vendors. You're going to start dealing with IT. You're going to help determine, are you going to have an IT-assisted collection? Are you going to have an employee self-collection? No. Highly sanctionable. Where is the collection going to be? Is it going to be in your office? Are you going to travel to the office? Is it going to be remote? Is the vendor going to travel there? You're going to help set all of this up. If you're in a meeting where you're talking about collection, this is how you can assist. Also, it's very important that you understand what a defensible collection is. The EDRM has wonderful resources that will give you documents on how to plan your chain of custody. Well document that collection plan. That is also, we'll talk later about the assessing technologies. Is a vendor going to have that defensible collection plan? And when you talk about choosing a vendor, you want to make sure that that vendor, number one, is not hired by opposing party in the same case. And if it's a vendor that opposing party, if you work on these cases enough, you start to know vendors work with certain parties, find a new vendor. You can't use a vendor that's working on the same case with opposing parties. Okay. So you're going to assist with the preparation and implementation of a defensible collection plan. You're going to help find the vendors. You're going to help assist with the collection. You're going to liaison with collecting the data. You're going to oversee and document the collection process. You can track, compile, and organize the data that you get in. Oh, what did Sue Smith give us? Here it is. Great. You're going to interview and assist in the selection of vendors, as I discussed. Okay, so what is defensible collection? If the collection is not supervised and an employee does not collect relevant ESI, it's highly likely the collecting party will face spoliation and sanctions at trial. I would highly recommend that employees do not do self-collection. Not necessarily that they want to hide things. They don't necessarily know how to do things in a defensible way. They don't have a legal mindset. They have no understanding of how their piece of information fits into the bigger picture. So oversee vendors. You can't just rely on the vendors to know what they're doing. You also have to oversee them. Ultimately, that's the attorney's responsibility, but you can definitely assist with that. You can follow up with the vendor. Oh, did you collect that data? How was it done? If it wasn't done properly, have them go back, revisit the process before you find yourself in court on the stand talking about it wasn't done defensively. Okay, so process, review, analysis. You're going to help format the ESI for review and culling. You're going to be separating attachments. You're going to help figure out what is duplicative. You're going to help review the ESI for relevancy. Is it responsive? Is it privileged? Help separate that. That's largely what we do as paralegals anyway. You're going to help analyze the data. Did we get everything that we needed to? Did we do our reasonable search? So by determining in the process review and analysis stage, you can help reduce costs by minimizing the volume of ESI that you're going to be reviewing. Paralegal tasks. You're going to assist with the identification with proper review tool for data. What is the proper tool that you're going to use to help you sort through all of the information? No longer are we doing, like David talked about, printing out all the emails and page by page. You might have a case that has 20 documents. You might have a case that has hundreds of thousands. You might have terabytes of information. There are going to be different tools to help you in different cases. So it's really important as a paralegal being able to identify those vendors that will be able to help you on a certain case. There are certain vendors who work best. You might have a case that has a lot of voicemail that needs to be transcribed. You might have a case that has a lot of blueprints or a lot of Excel spreadsheets. What are the type of review tools that are going to help you best in that situation? You're going to talk about data and metadata extracting, deduping, separating attachments, as I mentioned. You're going to help develop key search terms. I was talking to a friend of mine who is no longer a paralegal. She's an eDiscovery project coordinator, I guess you could say, like I am. And I asked her, what is the greatest place where paralegals can have value in this whole process? She said, developing key search terms, learning how to search the data in the shortest amount of time, getting exactly what we need. There's no magical formula, but this is the most costly phase, is sorting through all of the information. So, being able to sort through all of that information and discovering where the holes are, that is very important. Not looking at only what you do have, but looking at what you don't have. Is there a glaring omission? Are there a series of email dates that are missing? Or do you know that in your timeline somebody should have had a job evaluation that's not there? You know, look at what you don't have as well as what you do have. And what is the story that the data is telling you? Okay, production. Putting the bait stamps on everything. Those are still, running it through Adobe, making sure that you can transmit that information in a secure way. Are you going to be using an FTP site? Are you going to be using a CD that hopefully has a password that you've not transmitted with the CD? Those types of things. Are you going to be using hard drives? Are you going to be, how have the parties agreed that they're going to produce this information? Are you going to help them get it produced on time? And you're going to make sure, right, only the unprivileged information is produced. So, what is production? Production is the product of a review of the data identified and collected. Okay? So you're going to prepare those documents, make sure the bait stamp's on there, and you got your prefix right, and it all makes sense and looks nice on the index. So you're going to be preparing those documents for production after irrelevant and privileged information has been eliminated from the data set. In agreed format, kept in usual course of business. And it has to be in a usual format, usable format, or it has to be produced in what, if there isn't an agreement, how it was kept in a usual course of business. So, as David pointed out, printing out an email and scanning it back into Adobe, that's not going to work. So if someone's asking you to prepare a production and you know this isn't right, you can raise a red flag. That's highly valuable to be able to prepare that ahead of time instead of sending it in the wrong format. You can refer back to that discovery plan after the meet and confer. Make sure that that's the agreed format. Maybe there's a new associate who's like, yeah, we're going to prepare this production and can you get this for me? And this is how we're going to do it. Double check. Make sure that it's going out in the right format that was agreed upon. Review productions for deficiencies and prepare indexes. I know that sounds, a lot of these things can be automated in many situations, but in a lot of ways it's not automated. So what did you get? But also, as I said before, look at what you didn't get. Are there any holes in the information that you received? So you're going to also assist in the prevention and identification of inadvertent disclosure. David mentioned really shortly a clawback agreement. I imagine these big giant talons, give me back my information. Once it's out there, it's out there. Even if somebody can't use it in trial, it's out there. You don't want that to happen. So maintain and organize also responsive ESI and privileged document index. And as was mentioned before, lots of times those things aren't automated. Okay, so if you're reviewing things, attorneys are gonna have the last say. If they don't understand that, make sure you make them understand they need to review things for privilege. They're the last set of eyes to look at it. I really loved it when David said if they're not the first to understand, make sure they're the last to understand that. So, Federal Rule of Civil Procedure 26 again. Party may expressly claim the information is privileged without revealing the privileged information in a manner that will enable the requesting party to assess the claim. So you have to learn how to formulate that privilege log correctly. That identifies the information without revealing exactly what it is that's privileged, but allows people to understand, oh, okay, that's a valid claim. Okay. Because nothing is worse than somebody spending hours and hours on a privilege log that cannot be used. So let's say you take all of those steps and something inadvertently gets produced. It happens. And with electronic data, it can happen easily with a push of a button. So what do you do then? Don't hide it. Talk to your attorney as soon as possible. Notifying requesting party of claim and the basis for it. Okay, that's for the actual privilege claim. So after the other party needs to be notified, whether you accidentally produced something that was privileged or they produced something privileged. The other side needs to know about it quickly. So that also emphasizes the importance of reviewing discovery quickly after it's received. It can't sit on your desk for a couple of months before it's looked at. If that's one of your tasks, put it at the top of the list. So if you receive something, a document that was produced inadvertently, you have to promptly return it, sequester, or destroy the specified information and any copy of that information. The requesting party must not use or disclose the specified information until the claim is resolved. Are you going to take it to the judge? Is it something that you're going to want to be able to use make sure that you're handling that information correctly. Okay, so how to avoid, if you inadvertently disclose some information, there are steps that you can do to avoid waiving the privilege. Federal Rule of Evidence 502. Inadvertent disclosure of privileged information in federal proceedings does not waive privilege if the disclosure was inadvertent and you took reasonable steps to prevent the disclosure. Yeah, it wasn't just you didn't look at the document correctly. Was it a computer glitch that happened once? That might be something that the judge will look at and see as inadvertent. The holder promptly took reasonable steps to rectify the error. You know, promptly is the key word there. It can't be something that you wait a couple of months to tell somebody about. If you see that someone has disclosed something that it was obviously inadvertent, you need to tell somebody about it. So this case, Alcon Manufacturing, during the review process, a document was waived, or a document was identified as privileged and included in the privilege log. An electronic document break error, however, caused the document to be produced to the defendant. This is an example of how privileged document may be inadvertently produced. This was something that maybe the judge would forgive. Presentation. So the presentation of all of your electronically stored information, you have an important role at this. Are you going to be the attorney that's going to be presenting the information at trial? No. But you might be the one who knows about the trial technology that's going to help them present it at trial. So you're going to prepare those documents, you're going to prepare the exhibits for the hearing, the deposition, the mediation, the trial. You're going to develop and assist in implementing a presentation strategy. How are they going to be put together? What is the tool that you're going to use? Is it simply going to be a PowerPoint? Are you going to be using some fancy software at trial? These are all things that you can inform yourself about and suggest. So when you prepare the exhibits, definitely test them. You know, one of the things, not even taking depositions live anymore. You're doing that via telephone conference. Are those exhibits going to work? Is it going to present well? Is it going to give a good image? Is it going to give you something that you can use later? Those are all things that you're going to think about as the paralegal on the case. So we'll also briefly talk about the evidentiary issues. Electronic information presents a lot of issues with evidence, authentication and admissibility. Those are things that you can think about as well and assist with presentation. And then you're going to present, store, and maintain exhibits for trial and beyond. Okay? So, in preparing the evidence, you want to think about the admissibility. Is it relevant? These are things that they teach attorneys in law school, but I think it's really important for paralegals to understand how the information that they're collecting, that they're reviewing, that they're processing, how is it going to be used? I think it's so important to think about the big picture, because that way you have an extra set of eyes and nothing gets missed, hopefully. So you're going to think about how relevant it is. Is it going to be admissible in court? If you properly have it authenticated, maybe it will. And we'll talk about a couple of ways that you can. There are unique hash values, and that's another one of those terms that Sedona, the principal, their electronic dictionary will help you understand the unique hash values and their importance in electronic information. You're going to potentially use requests for admissions. When you're asked to prepare a draft, you're going to know how to properly word them to authenticate a document. Are you going to ask someone to do a deposition upon written questions, and you're going to include the right questions? All of those pre-trial disclosures, you can use those to help authenticate a document. Hearsay, understanding what that is, and how it applies to emails, texts, social media posts. Somebody who was involved in a car crash and was texting about a breakup with their boyfriend right before, that might be able to show that they're culpable for the car crash, and that might be able to be used under Federal Rule of Evidence 801 or 803 because it's an exception. They're talking about their state of mind. So authenticity of a document. A party seeking to establish authenticity has only to make a prima facie case showing that the ESI is what it is claimed to be. And how do you do that? You offer a foundation from which the jury could reasonably find that the evidence is what the proponent says it is. In Lorraine versus Markle American Insurance Company. That's so what are some documents who are self-authenticating? Government agency websites. Equal Employment Opportunity Commission versus EI DuPont de Moores. You know what? If you are getting information from a government agency and you go ahead and include that custodian certification, it comes down to trial time, and that's done, and that's something you don't have to do at the 11th hour. I've been preparing for trial, and paralegals have not gotten that authentication document. Maybe we have to make sure that they can appear at trial to testify. Yeah, I stamped that document. You don't want to have to do that. You don't want to have to make somebody miss a morning at work to authenticate a document. So if you have an understanding of the big picture, how the information is going to be used for a deposition, at trial, a hearing, that's going to make you a superstar. Okay. So hopefully I'm doing good on time.
10 more minutes.
Oh, excellent. Okay. So one of the wonderful things, the best piece of advice that I got from a webinar that I did years ago on eDiscovery, do the simple things well. You will be surprised how many people cannot just get the simple things right. You sent out the subpoena but didn't follow up on whether somebody responded to it or not in the window of time that they were supposed to. Calendar those little things. Follow up on that hold, even though maybe your boss didn't tell you to. Be a technical and eDiscovery ambassador. Right now, it's wonderful that you are all here, and thank you for your time. But in the near future, this isn't going to be an exception that somebody knows about these things. It's going to be a requirement. So be that person in the law firm that's slow to adjust to all the technical new rules and information and formats. Be that person who volunteers to work on that case. Educate yourselves. That doesn't mean just appearing here when vendors ask you to lunch or want to present information. Take that time to hear what it is that they have to present. It adds to your little toolkit. I can't believe how many times that I've just said, oh yeah, sure, I'll learn about that, and the next week I'll have a case on it. So education, that even if it means educating yourself on your own time, do that. It will set you apart. So if you have any questions, you can feel free to email me as well. But if you have any questions now, I would be happy to answer those. I know it was a lot of information. It is a lot of information. But hopefully, if you're not already working in eDiscovery, once you have this information, you'll start working on cases where it'll start clicking and you'll start understanding, oh, okay, this is how I utilize this. Any questions?
Can you send us the PowerPoint presentation?
Yes. Yes, I think that would be fine, right? That'd be fun. Okay. I know you're not going to write down all of the case law and those little fine technical things.
So the Sedona Principles, what is that exactly? Is that like a restatement of the law kind of? Is that what that is?
Actually, the Sedona Conference is a think tank that got together, I think probably about 20 years ago or so, and they kind of got together. It's judges, it's attorneys, it's technical experts who all got together, and just like the EDRM said, this is the best way that we've found in the process, because case law was not filling that gap, the rules were not filling that gap. People are running around with their hair on fire like, we don't know how to do this and we're going to get sanctioned and So all of these leaders in the industry got together and said, this is how it works best for us. If you want to protect yourself and protect your client, this is one of the best ways and processes to use. So I think that there are about 14, 17 main Sedona principles. They talk about how to issue a hold, how to preserve information. It's a great resource. It's actually a necessary resource for you to understand and know.
To add to that, the Sedona Conference came out, I said about 20 years ago or thereabouts. It was right after the Zugalot case came out in New York, before the federal rule changes, the original rule changes in 2006. And it was a bunch of judges and lawyers who got together as a think tank to figure out how do we address the eDiscovery practice. Because the federal rules did cover it, but not in the detail of electronic data. So they came out, they put together these policies and these principles, which then molded the original federal rules that were changed in 2006. Well, if you read those rules compared to the present changes that just took place, it's very one-sided. So it's very plaintiff-driven. I won. So now you have this change in tone of really mirroring out the process. So the Sedona Principles, you can go out there, Sedona, I think it's a .com or .org address. Because most of you are all students, I think it's free. You can join at no cost. Same thing with eDRM.net. It's free, I believe, to students. So you can go out there, download, not even have to be a member to download all the principles. It is a great educational process, as you were talking about. So it's a good resource to be able to drive and really understand what's going on in the eDiscovery world. As you read the federal rules, it will reference the Sedona Principles, even the new rules. So if you're not familiar, you'll get confused as you read this because the rules and the rules are never clear. So that is a piece of the puzzle.
Yep. All right. Well, thank you, everybody. I feel like I'm forgetting something.